Good morning, Chair and Ranking Member. My name is Will Estrada. I'm Senior Counsel at the Homeschool Legal Defense Association. I'm a proud homeschool graduate, proud homeschool dad, and proud Puerto Rican. I oppose HB 2827 as originally introduced and the amendment because it's premised on two mistaken assumptions and will do two harmful things. Mistaken assumption number one. You've heard from the proponents their claim that children who are being homeschooled are at greater risk of abuse and neglect. This is not supported by the two peer-reviewed studies that have been produced. I have copies of those. I could talk about this for hours, but in the interest of time, I won't. I'm happy to answer any questions about that. Mistaken assumption number two, homeschooling is unregulated in the state of Illinois. Now, we heard some of the proponents say that there are no regulations, and then we heard that there are things that homeschoolers have to do. In the 1950 landmark case of People versus Levison, the court made it very clear that homeschool parents had to educate their children, had to teach them the required subjects, had to do better or the same as the public schools, and if they didn't, the burden was on the homeschool family to show this to the authorities. Again, I could talk about this for hours, be happy to answer any questions that you have about it. As well, it's important to note that DCFS is there to investigate cases of abuse and neglect. This should not be put a burden on the public schools. DCFS is underfunded, overworked, and instead of putting more burden on them, we should provide greater funding and support for our hardworking caseworkers. And then Illinois has robust educational neglect laws. Those are the two mistaken assumptions, and here are the two harmful things that HB 2827 would do. The first one is it would allow the regional offices of education in Chicago public schools to come in at any time and do reviews of the family's educational portfolio. Section 40 has been billed as just applying to when a family comes up before DCFS, but there's actually several different parts of it. I want to read the last sentence of Section 40. The Regional Office of Education, Intermediate Service Center, or School District has the power to conduct an investigation to see if a homeschool declaration form under Section 20 has been submitted for their child and any other investigations, plural, as needed. Section 25C gives these same authorities the power to request the educational portfolio at any time. This will be a burden particularly on vulnerable communities, those who lack privilege to hire attorneys, and other people who are most at risk of coming into contact with our criminal justice system. Which leads me to the final harm that HB 2827 will do. Criminalization of the failure to file a piece of paperwork. We heard a lot about where Illinois stands with other states. Not one single state in the nation, even highly regulated states like New York, Pennsylvania, Massachusetts, and Rhode Island, make it automatic criminal Class C misdemeanor, 30 days in prison if convicted, $500 fine, criminal conviction, potential removal of children and placed in temporary foster care if you fail to file paperwork. Pennsylvania, for example, which has high regulation, says that it goes through a 30-day review process, independent, impartial review, and then the highest penalty is you can't homeschool for 12 months. This will make our most vulnerable communities at risk to prison, a criminal conviction, when we're going in a direction of trying to reduce the people in the criminal justice system. I could go on, but we've got some great witnesses. Happy to answer any questions. Thank you very much.